The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer some frequently asked questions about family law. We'll hit on topics of divorce, child support, parenting time, and spousal maintenance. I'm going to give you quick and dirty answers to all of these topics because at the article associated with this video at learn-about-law.com, we have links to more in-depth videos and articles about each of the answers that I'm going to give you. So we'll try to go quickly through each one and give you a broad-based overview of family law in Illinois. So first, let's start with what is an uncontested divorce. A lot of people ask what the quickest, easiest, cheapest way to get divorced in Illinois is. And generally, it's an uncontested divorce. There's something called the joint simplified divorce that can apply for some people. That is a form of uncontested divorce that's even faster and cheaper. But there's a very small segment of people that applies to because it requires almost no assets and no child-related issues, no spousal maintenance. But if you can't qualify for a joint simplified divorce, anybody can do an uncontested divorce. And an uncontested divorce is simply when the parties negotiate and come to an agreement on all issues surrounding their divorce, issues like spousal maintenance, child support, parenting time and responsibility, division of assets and liabilities, and they come to an agreement on this before filing for divorce. And in this case, there's nothing to fight over, nothing to litigate. So the divorce only takes about a month, only requires one court appearance, and it can be very inexpensive. So next, let's talk about what is the difference between a legal separation and a divorce. So people are familiar with living separate and apart prior to getting divorced, but a legal separation is a little bit different. It's an actual court case that resolves issues regarding spousal maintenance, child support, parenting time during the period of legal separation. So you get a court order at the end that resolves a lot of the issues while the parties are living separate and apart. It makes sense if the parties are trying to reconcile to do a legal separation, and it's because it lacks the permanence of divorce. If the legal separation and the reconciliation during that legal separation fail, then the actual divorce itself becomes a lot more simplified, a lot less costly. There's less to fight about because a lot of your issues have been worked out in the legal separation. Now, they don't automatically translate over to be locked in for the divorce, but you can use that as a baseline going forward. And if the reconciliation does fail, you can always then file for divorce. Next, let's talk about what is a joint parenting agreement. A joint parenting agreement is an agreement between parents who are getting divorced or parents in paternity cases where the parents are unwed, where they agree to how they're going to divide parenting time and responsibility. If the parents can't come to an agreement on this, then the court will order mandatory mediation to have a neutral third party help them resolve these issues. If the mediation is successful in resolving all these issues, then there will be a investigation by the court and possibly a guardian ad litem, which is someone who's responsible for investigating, advocating for the child, and reporting to the court. The guardian ad litem will likely be appointed, and there will be a hearing at which the court will enter a final parenting order. A marital settlement agreement is similar. So the next question is, what is a marital settlement agreement? This is often known as an MSA for shorthand. A marital settlement agreements can resolve all the issues other than parenting time and responsibility. So it can deal with issues of child support, spousal maintenance, divisions of assets and liabilities. And like I said, if you have a marital settlement agreement and a joint parenting agreement before you file for divorce or at the outset, then a divorce can be very inexpensive. It's the end game of a divorce is to try to reach settlement on all of the issues and hopefully not have to go to trial because trial can be costly and stressful, and it can take a while to resolve. Next, let's talk about how do courts determine parenting time in Illinois. If the parents are unable to resolve their parenting time through a joint parenting agreement, the court will, after a hearing and investigation, set a parenting schedule through a court order. We've spoken about that already. When the court is making the determination about how to divide parenting time, they're ultimately looking at the best interest of the child. That's the standard they use. But they weigh several factors in order to determine the best interest of the child. These can include the wishes of the parent, the wishes of the child, the wishes of the child are more important as the child gets older, relationships between each parent and the child's adjustment to their home, school, and community, and the mental and physical health of the parent and child. And there's other factors that we reference in our article that goes more in depth on this subject. But factors like that are what the court will weigh in determining how to determine the child's best interest to divide up parenting time between the children. Next, let's talk about how is child support calculated in Illinois. So child support in 2017 in Illinois changed over to an income shares model, which means that the income of both parties is taken into consideration. Prior to 2017, only the income of the obligor, the person paying child support, was taken into consideration. So now courts use economic tables to determine how much the total pool of child support that each parent is that the parents collectively are going to be responsible for paying. So together as a parenting unit, the child is going to get X amount of dollars in support based on a number of factors that are laid out in this economic table that the court will use when applying the guidelines for child support. Once we determine the total pool of money that's going to be attributed towards child support between the parents, each parent's share and responsibility for paying a percentage of that amount is based on their incomes relative to one another. So if you make more, you're likely to pay more in child support if you're the obligor. However, because we've switched to this income shares model that takes into account both parties' income, if the recipient makes more money, they're likely to receive less in child support. But it's weighing the income of each parent against one another. And one of the strengths of our blog is we have a lot of child support articles, and we flesh out almost every issue you could possibly have a question about in child support. So check out learn-about-law.com if you want to know more about this. We'll talk about one other child support issue, and that's how is child support calculated differently in shared parenting situations. So a shared parenting situation is when each parent has the child for at least 146 overnights per year. In a shared parenting situation, the total pool of child support that's attributed to the child that the parents are collectively responsible for is increased by a factor of 50%. However, the amount of time that each parent spends with the child serves to reduce their child support obligation. So in a shared parenting situation, if you're the obligor, the more time you spend with the child and spend responsible for that child, the less you are likely to pay in child support. And this makes sense because in a shared parenting situation, if you are financially responsible for the child on a greater day-to-day basis, you should pay less to the other parent in child support. So next question is, when do courts award spousal maintenance in Illinois? So spousal maintenance is the same as alimony. It's money that one spouse pays to the other in a divorce, basically not for the care of a child, but just for their own care. Courts don't always award spousal maintenance, so they weigh several factors when determining whether to award spousal maintenance. And these include, but are not limited to, each party's income and earning capacity, each party's needs, the standard of living that the parties enjoyed during the marriage, the duration of the marriage, and the contribution of one party to the other's education or career, and this includes contributions as a homemaker. There's a bunch of other factors that we discuss in more detail in the article and video dedicated to the subject at learn-about-law.com, but the courts weigh those factors and then determine whether to award spousal maintenance at all. So the next question is, if the court does determine to award spousal maintenance, how is spousal maintenance calculated in Illinois? This is a two-step process, so really a three-step. The first is determining whether to award spousal maintenance, and the second step is determining whether to apply statutory guidelines in determining the amount and duration of spousal maintenance. So courts will generally apply statutory guidelines to determine the amount and duration of spousal maintenance if the combined income of the couple is less than $500,000. If it's less than $500,000, statutory guidelines will be applied. If it's more than $500,000, the court has discretion to deviate upward from those guidelines. They can deviate upward or downward, but it's generally upward. So then step 3 is, if we are applying statutory guidelines, how are the amount and duration of spousal maintenance calculated? And it's a pretty simple calculation. The court will subtract 25% of the recipient's net income from 33.33% of the payor's net income to arrive at the amount of spousal maintenance that will be paid. And this is capped at 40% of the parties' combined incomes. So if you want to learn what net income is, we have more about that at the article devoted to this, and how we get at that. But it's the income from all sources minus certain things that can be deducted from the income. So that's how you get to the amount. Then the next question is, how do you get to the duration of spousal maintenance? How long do these payments have to continue? And this is really based on the length of the marriage. So there's a table that courts use that, based on the length of the marriage, the longer the marriage goes, the longer the duration of spousal maintenance is, and it gets closer and closer to the duration of the marriage as you get closer and closer to 20 years. As you get closer and closer to 20 years, the duration of spousal maintenance gets closer and closer to the duration of the marriage. Once you hit 20 years, it's at least 20 years of spousal maintenance, but it might be for an indefinite term, and anything past 20 years is going to match the duration of the marriage or be for an indefinite term. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and you'll be notified of our daily article and video posts. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.